continue to do training together. Those factors right there are not Andy's factors for a successful program. Those are also research-based. They are based in implementation science. If a program can check off yes, or you as an advocate, you as an attorney can check off yes or positive to those things, that program is going to perform well or outperform programs that don't do that. And that performance can make a big difference in terms of how many kids come back into care. And so a couple advanced practice items for you guys before I hand it back over is that treatment plans. If you go to any provider in the state and you ask them, are somebody's come in for a substance abuse problem, or do they have a treatment plan? They're going to say yes. Now, if you go to any participant in the state who's in programming and community-based treatment, you say, what's on your treatment plan? They're going to say what? I have no idea what you're talking about, is what they're going to say. Or they're going to be like, yeah, I have a treatment plan. Well, I'll be, what's on it? And they'll be like, I'm not exactly sure. That's not helpful. Do you know what's on your treatment plan when you go to the doctor? You should. Because you should be a partner in this, just like the participants should too. So you need to have clear treatment and case management plans with very clear goals, and they need to be measurable. What somebody's asked to do, it should be measurable. And that's something that that's more of an advanced practice than just a typical practice, but you need to see that in place. You should see it for all of your clients, but definitely for an FTC. And then are they being rated on that? Like, are participants who are doing badly with their treatment and case management plans, are they getting feedback on that? And does that translate into what happens in the courtroom? Is that person receiving sanctions if they're getting low ratings? They're not doing the work, they're not making an effort, they're not being accountable. Is the person who's doing great on their treatment plan getting incentives? You should look at this as an attorney, and that's easy enough to measure, right? I should be able to look at the ratings and look at what happened. And the one thing that these types of courts should be able to do is ensure that participants who are in the program are making an effort and are showing up, and that there is good oversight. And we have what's called behavioral modification. We have contingency management. They're not coming into these programs, guys, because they're so motivated to change their life. They're coming into these programs because they want to avoid the consequences associated with their addiction. They don't want to lose their children, but they don't want to continue to face consequences. We can work with that. It doesn't matter why they come in. They don't have to be particularly motivated. They just have to be motivated enough to come in and then let the program work. Because the head follows the feet. If you get somebody to enough sessions, you get enough high quality treatment in them, their thinking will come along. It may take 3 months, it may take 6 months, it may take a year. But that leads us to the other thing, is that are there scripts in the court? Is the courtroom separated from what's happening in treatment? And the courtroom should be connected to what's happening in treatment. Which means that those skills, those cognitive behavioral skills that I was talking about, whether it's to address relapse or address recidivism, the judge should be engaging the participants on those skills. The judge should have a cheat sheet, know what the participant's working on, and engaging them. And if any of you have sat in or choose to sit in a family treatment court, if you don't hear skills, they don't have any skills. And that's always my message to judges, whether it's felony, juvenile, or family treatment court. If you don't hear any skills happening, they don't have any skills. And if they leave this program without any skills, what's going to happen? They're going to be right back. And so one of the highest, order things that we can do is make sure that we're using court to reinforce these skills all the time. And then lastly, do we maintain rigorous oversight all the way through? I do not want to hear about family treatment courts where they say, the participants do so well that in that last 6 months, we don't really do as many drug screens. We really want to get them back into the community and, let them know that we trust them at that point. No, our job is not to trust them at that point. Our point, we can love them. But our point, we are there to maintain oversight. It's about child safety. It's about children not returning to the system. And they need to be working on stuff as long as they're in that program. There needs to be a level of accountability. There's other ways to support them toward autonomy. You can reduce the amount of treatment that they're engaged in. You can encourage and reinforce them doing things in the community, doing things with their children, and using these skills actively. You don't do less drug screens and less accountability. We need to know that every person who leaves an FTC leaves clean and using skills, and they have the best chances of holding it together, because you have the same thing that exists with a diet or quitting anything, and that is regression that happens. or if anybody's ever been in a sports program or athletics program, what happens when you, as soon as the coaching ends? Or as soon as you stop paying for that coach at the gym or trainer? Because what happens, you start to regress a little bit, right? What happens, with our diet, we start to regress a little bit. These participants, when they leave FTCs, are going to regress. And then we get to what is their survival? What determines survival for them, which is staying clean, taking care of their kids, being accountable, and living a new life that they have worked so hard to earn. Well, it's going to be, we need to make sure we get as many skills into them as possible, and that they really know how to use those skills, and it's reflexive for them. Just like the skills are for you guys. They got you here on time, and got you through your day, and got you through law school. They need to be doing the same thing. And so with that, FTCs. In Georgia, we have a higher retention. We have a very high retention rate. That's good. We have a fairly low return rate relatively speaking. All the judges freaked out when I talked to them about the actual return rate. And I said, well, it looks like about 18% of kids came back in. But when and they were like, we don't want any kids coming back in. Well, I don't want any kids coming back in either. But I'm realistic. And when the average participant who came into this program had a 50% chance roughly of being rearrested, that rate was obviously reduced quite a bit during programming to only have such a small percentage of kids come back into care. Because if nothing was happening, then 50% would have gone on and gotten rearrested, right? And they're addicted to criminogenic drugs. These are not low-level cases. So a lot of good work is happening. If you look at the offender research and think about reducing risk, if a program with moderate risk of offenders in the felony world reduces risk on average by 50% or so, and so the majority of participants walk out and their chances of coming back is 1 in 5. They are doing the Lord's work. They're doing incredible work, and that's a Mars landing if you're doing that type of work. FTCs are trying to do that, have to do that very thing, but it's not just, it's like a felony drug court plus, because it's about kids. It's about kids not coming back into care. So lots of good work, lots fraught with challenges, no doubt, and we'll get a chance to talk about that. But there is a lot of good work. But these things on that checklist, that's not easy to accomplish for a program. And we just need to make sure that they're resourced to do that. So with that, I'll turn it over.
Andy, can I ask you a quick question before we move on? So I don't think I'm quite ready for advanced practice, because I'm trying to think about clarifying when you refer so often to risk, and I think about we really mean risk of reoffense, but in different contexts, all of which are trying to be served by this model of intervention. A reoffense in a criminal context means a new crime, right?
Right.
Reoffense in a child welfare maltreatment context means repeat maltreatment. Reoffense in a clinical context means, that you relapse and use again. So, and obviously we have different, mostly tools on the criminal side to think about assessing risk and managing that within our therapy groups.
Right.
What of that assortment of risk can we really think, are you talking about when you talk about not, for example, not mixing risk in this paradigm? Do you know?
Yeah, and I'm glad that you clarified that, because I am I'm talking about there are several different types of risks at work in a family treatment court. There's risk of child abuse and neglect. There is risk of relapse, and then you've got risk of reoffense or continued criminal behavior, and then you have some other risk factors too. We have to prioritize services on trying to reduce those three primary, which is abuse and neglect, which are very much tied to reducing relapse, but also reduce criminal behavior where it exists. And when I talk about not mixing risk, I mean it's as much as possible when we do an assessment, we want to ensure that like participants are served in the same context. And the participants who have differences, marked differences in terms of trauma, in terms of criminal risk, in terms of their drugs of abuse, that we separate them as much as possible. And that's the best clinical practice, to separate them, and then to match services to their needs as well. So not everybody who comes into an FTC has criminogenic risk. They're not, they're not necessarily at risk for being rearrested. And some are not addicted to heroin and crack cocaine or methamphetamine. But those who are need to be treated, they need to be separated and treated differently and make sure that we ethically give them what the level of services that they need. Does that make?
It does. So when you talk about risk, you really are talking about a sort of more global, holistic
Yes.
set of.
Yeah, and we need to assess each aspect of it. And when I did refer under best practices, I'm asking that we supplement the assessment work that we're already doing, the assessments and tools that we're already using, with a criminal risk assessment as well. And even though it's a non-criminal context, if you have individuals who are at risk for being arrested, that's a big driver of return to care. And we should just make sure that we, as a policy, as a practice, address that as well. FTCs are doing that in Georgia.
Thank you.
Oh, you're welcome. All right.
So one more question.
Yes.
Actually, two. Okay, two more. When you say 15% risk, what's the line? Re-enter care?
Excuse me?
What's the line? That a child re-enter care, or there's a new substantiated case, or there's an arrest?
When we talk about
What's the line?
it's substantiated case.
Okay. And then I'm assuming that there's a screening process for someone when you get in family court. Does that include clients with dual diagnosis, or kicks those out?
It does include clients with dual diagnosis. Now, resources vary from jurisdiction to jurisdiction in terms of, especially some of the rural jurisdictions, in terms of what's available, but dual diagnosis is considered, and a high percentage of the family treatment court cases in the state do have dual diagnosis as well. And there does need to be specialized programming for that. We're weak on that in the community, by the way, community-based treatment, but the FTCs are addressing that. And there is a screening process. In fact, the Georgia legislature, where the governor just signed legislation indicating that DFACS does need to be screening and prioritizing cases for FTCs, needs to come to the table with the FTCs to arrive at what that screening process is going to be. And the reason for that is that we don't have a standard set of criteria for going to an FTC, and that it should be fairly obvious, but there are huge caseloads, and we need to make sure that we have a metric or very clear, concrete criteria to say, hey, this looks like a case that's a good candidate for an FTC. At least flag them for an assessment and see if that is the case, and if so, move forward from that. But don't wait until they've washed out of every other service, and at the end of their timeline at that point. And so all the FTC has is a couple months left on the after timeline at that point. We want to try to refer these cases, get to them early, and flag the ones who are in need. And we don't need to be referring everybody to an FTC. We need to refer those who really need it, who need this level of oversight and care. My argument would be that there's a much larger percentage of cases out there that need this level of services that can possibly be served by the FTCs. And so down the line, that there needs to be sort of a transfer, some of the things that seem to be working with the FTCs over to better serve those other types of cases. But we need to build an argument, and that's what we're doing right now. The jury is still out nationally. There's all sorts of positive indication, and the research looks good, but the jury's sort of still out on how much better these programs are functioning. And my position as an advocate for these programs is I want to see them focus on these best practices and advanced practices to ensure that they do get the best outcomes so that that transfer can happen. Because we're underserving a large percentage of the population, DFACS population, and we're waiting way too long to get them into the appropriate level of services, even when they exist. And while I may understand that, because I believe in personal liberty and I want to give people chances, there are kids who end up in long-term placements, end up in foster care, or end up being adopted out that didn't necessarily need to happen. When it does need to happen, fine, but it doesn't necessarily mean to happen. It shouldn't be the case that it's happening because we're underserving them, or we're not getting to them soon enough, or giving them too much time. That's basically my argument, but I hope I answered your question, sir. Did I?
You did, and it raised another question, but I'll defer to Jennifer.
So with the family treatment courts in Georgia, are the families are the children in the custody of the department, or are they entering the family treatment court prior to an adjudication and entering the custody of the department?
They, in almost all cases that there's been a finding of dependency, and so they are under the supervision of the department. And now they're not always in an out-of-home placement at that point. They may be supervised in the home. And the focus is to try to get them before they do get, to try to get to them early enough that there doesn't have to be the overutilization of foster care, or out-of-home placement. Because obviously with the level of oversight and services, there's many cases where kids could stay in the home rather than being transferred out and then brought back in later on, and have to be reunified later on. That if you got to clients soon enough, that you should be able to avoid having all the placements. That's the goal, and we're moving in that direction. But there's so many kids who are in foster care or in out-of-home placement that those are the priority cases right now. Does that make sense?
It does, so it's post-adjudication, active foster care cases where you're trying to reunify the child with the parent, but ideally you'd be catching it on like the family preservation end.
Yeah.
Okay.
And there's some variability between different defects departments and how they are referring. Some are referring earlier, and if there's good coordination with the court that's happening. We hope with the screening protocol, if it gets in place and there's fidelity to it, that we can start catching those cases earlier and earlier, so we don't have to go to foster care in the first place. And that was really what the focus was of the Casey work in the first place, which is to avoid utilization of foster care wherever possible. And then promoting stable reunification, which is the other thing.
You answered the question that I had because she asked it, but then it raised another one.
Is this the fifth question?
Yeah. Private dependency cases where a court adjudicates dependent but protective order in place. Would those also possibly involve a FTC when DFACS is not yet involved? Could potentially be involved.
Every single one of your questions has been great, except that one. No, that is a great question. This just came up actually in a jurisdiction for me last week. Typically, there's a formal finding of dependency. They're not private dependency cases because the services are not necessarily, the services that are contracted for by DFACS are not available necessarily if it's a private dependency case. And but this issue has just come up, and it is theoretically possible, yes. There's nothing that bars a private dependency case from coming into an FTC. It would just be a matter of can we provide the right level of services. With the family treatment courts, they have had to move to a blend of community-based treatment, which is third-party reimbursed, which is reimbursed through the state. Some cases insurance doesn't get you a lot of treatment, anymore. I don't know that it has in a long time. But they've had to use a blend of that and then bringing in private contractors to deliver more responsive services. Those types of services that we were talking about earlier, they don't exist in community-based treatment. Those are the types of services that would be available in a private dependency case. So as long as the jurisdiction has that and they can ensure that they can deliver the right level of services, there's no reason you couldn't get a private dependency case in there. And this, I think that we're going to be seeing more of that soon. Obviously, the focus has got to be on dependency cases because we have so many of them. Those are the priority cases and the foster care cases, but there's nothing that bars that from happening. And so if you have one, push it.
I have one.
Push it. All right, so thank you all so much.
So I'm going to pivot just a little bit and talk a little bit more about the research that Terrence and I did. We thought family treatment courts sounded like a great idea, but felt like there wasn't maybe enough material out there, enough research. Once we started looking, we found out that only the 8 states had standards, and as Terrence said, it gives us a really nice perspective, East Coast, West Coast, North, South, to kind of, and also we talked to courts in urban and rural areas. We're hoping that the guidance that we put together, the places that are forming standards going forward, will be a little more informed. They'll look at these 8 and say, this is great, this is what we need to build on. The standards were anywhere from 8 to 300 pages, so there's a huge variety of that. And if you are looking for guidance for if you're wanting to start your own court or practicing one, Children and Family Futures is really who I'd recommend to start with. They're a nonprofit in California, and they have about a 300-page guide. They've got sample MOUs for how you would agree with treatment providers in your community, how you would plan for your analysis testing, for transportation, all sorts of other issues that are going to come up with the wraparound services that a treatment court is ideally going to provide. So that's how we got started with our list. There are a lot of great information out there about drug courts and a lot of family treatment court. As Andy referenced a number of times, we're built off of the felony drug court model, but it's different when you're working with a family. So there's some good information out there from National Association of Drug Court Professionals, but we're looking for more treatment court. We did find one thing that was missing as we looked across all these standards. Nobody mentioned ethics at all. There was no issue addressing the conflicts that come up for attorneys, issues with who would practice and who would provide representation, issues between parallel and integrated courts representing parents and children. And so we felt like there was a lot to dig into. And that's why we reached out. We interviewed attorneys, court coordinators, and judges across those 8 jurisdictions. So I just mentioned some of the issues that came up. We found in 2 different places where an attorney said they had been appointed to represent the parent and also to represent the child within the same case. So there's obviously a huge conflict there. If they're representing the parent, they're saying they want reunification. If they're the GAL, they might be saying it's not in the best interest of the child. So huge issue with that. And also making sure the FTC reaches its goal, which I think most of us would agree the goal is faster reunification and better treatment services. And there's a lot of secondary goals, but preventing separation and faster reunification really are the goals, and making sure they reach it. Because as Andy gave us some of the stats, Georgia's reaching it and doing better. Some jurisdictions aren't. We talked to one program coordinator in New York who said they had a case that went on for 4 years. So while treatment court does take longer, it might take longer than a typical DFACS case, we need to keep in mind balancing that. And our last issue was confidentiality. So Terrence and I are going to talk about the issues that came up, and we came up with 4 main ethical issues that we thought any attorney in the system, specifically parent attorneys, but guardian ad litems, child attorney, SAG, anyone in there should really be thinking about if they're going to participate in a family treatment court. And talking about competence, really happy to have you guys all here today. I imagine you saw the topic and went family treatment court. Sounds like it was new for a lot of you. Maybe you wanted to be part of it or just wanted to learn more. And as we've been talking about and hearing from Andy and Terrence so far today, there's a lot of things that make a family treatment court different than your traditional dependency case. And so understanding all these things is so important. First, just knowing if they're in your jurisdiction. Andy's told us that there's 4 or 5 more that are about to open in the state, so we might find out if that's going to affect any of you guys today. Knowing what your client is going to be agreeing to, they will get a handbook, and in some states, the attorney is right there when they're discussing the rules and saying, do you want to join this program? We're going to ask you to give up some rights, to agree to your analysis, to agree to show up at court maybe every single week, and all these things, and making sure you understand everything that your client is agreeing to. In some jurisdictions, clients agree to that without an attorney in the room. So making sure your client has gotten the handbook, understands what they're signing and agreeing to, is competent to make this agreement too while they're in there, are all really important factors. So from talking to our attorneys, program coordinators, and judges, one of the most important things they talked about was understanding the Adoption Safe Family Act guidelines. So the guidelines nationally, and I know different states vary, is that a child is out of home for 15 out of 22 months, that the SAG is supposed to move for termination. And most times someone is in a family treatment court up to or longer than those 22 months. And when that timeline does reach, a lot of the practitioners said to us, we explained that there's a compelling reason not to move for termination. The parent is participating in treatment. But it's something to make sure that the client is aware of, that they've got this 22-month deadline looming over their head, that it's a very serious deadline, and they should know that the court might bump up into that.
understanding the court. It talked about knowing whether it's there, but also knowing the goal. Some jurisdictions said their goal was reunification. Others said it was permanency. For anybody that practices dependency court or child welfare in general, it's a huge difference in their goal. So we thought that was a really important thing to talk about. And family services, Andy touched on some of the things that can be provided and whether you're getting the dosage in terms of treatment. But we also talked about the dosage in terms of the services that were provided. One of the best was in Alabama. It's not the court that we saw the video from earlier, that was Jefferson County. But in Dallas County, they have really full wraparound services where they'll provide transportation for your child, get the child to therapy, get the parent to therapy, help with education. And they're having a lot of success with their program. So some of it, when a family treatment court is starting, is to make sure that they have these MOUs in place, that they're able to build a system, and they have a really strong network before they get started.
When you say child care providers, are you talking about daycare services or?
Yes. So if a parent was participating in an intensive program, that was one of the examples, or if the parent had court to help with that. So, in terms of an attorney being competent, how they could get competent, obviously coming today is a great step. A training should be offered. I know Andy's been going all around Georgia and has done some trainings with different groups and with judges, I think in particular, and that's huge. We found as we were talking that people have different expectations of their responsibilities, especially the attorneys and their ethical responsibilities. For example, we'll come back to this later, but to talk about zealously represent their client. The judge in the video mentioned that it was a non-adversarial court, and that's the judge's approach, but any parent attorney would say that they always need to be standing up for their client's rights, and they might see it as being a bit more adversarial. So understanding the timelines, everyone's obligations, and really making sure there's that background on substance use disorder and mental health. We talked to probably about half the attorneys we talked to felt like they had adequate training in those areas, and about half didn't. And one attorney said, both the agency attorney and I, we react differently now. We work together better. We understand what we're up against. So they felt training was really important on that. In terms of who should get the training, it's really not just for parent attorneys, it's for the entire team. And Terrence and I thought one thing that was really important was everyone understanding each other's ethical responsibilities. If someone is a service provider and under their state mandated reporting law, they're used to who they might report to or what they're going to share, that's going to be different than what the attorney thinks is appropriate to share. Might also be different than what the SAG thinks. So everyone's going to be meeting together in that staffing with the judge, and that might be every week or every other week, and they're all going to be sharing this information about the client. So understanding everyone's information is really important for that. And in terms of evidence-based practices, again, Andy talked about that a little bit. When we use that catchphrase in our interviews, only 2 states actually jumped to that and said, "Oh, we do that." And when we asked the other ones, they didn't bring it up, or they said, "Okay, yeah, evidence, yeah, we use practices." So that's 2 out of 8 states. And then when we talked about the family, the wraparound services, Alabama and Minnesota were leaders on that and had some really good plans for that. So the best way to get through this and to offer the training is really to have a set aside. Minnesota had it automatically as part of the state budget, and that made it possible for them to make sure they were training everyone in the state. In Virginia, they had a flexible model, and they said, we react to what comes up. When we had a new drug, we had cough syrup being used for the first time, we grabbed everybody together and we had an impromptu training. We got everybody together for an hour and brought in someone to talk to us about these risks. So again, it has to do with tailoring the right dosage and giving the right information to people. So we talked a lot about the risk level, and now I'm going to actually give you the right term for it. It's the level of service case management inventory and revised, the LSIR, and that's where someone is ranked for how many problems they're having, and also their likelihood to come back in court. And in Georgia, the average is 26, which is medium. But these all tie into things that Andy talked about in terms of the criminogenic factors. Something else that Terrence and I talked with our interviewees a little bit about is just how people were getting into court and their substance use disorder screening. And most of them were using DSM-5, and they did have that as something they were aware of. But again, it wasn't always a firm screening. There wasn't always a cutoff line of if someone is 24 or above, they're in the court. If they're 23 and below, they're not. So we think in terms of standards going forward, it would help to have a little bit more of a bright line. And studies have shown, I think these are Andy's studies quite potentially, that you have equivalent or better outcomes for participants who are coming in with co-occurring mental health problems. So I know someone asked about dual diagnosis. So it's actually the people who are in the worst situations that are benefiting the most from this intensive treatment, which makes sense. So people who are unemployed, less than high school education, who have a criminal justice history, who have risky housing, DV, and again, crack cocaine, methamphetamine, and alcohol in the studies. So ideally, I talked about that there should be moderate, that there should be kind of be that bright line from 18 to 40 is considered a moderate high to a high criminogenic risk. And in Georgia, they use a little bit of a soft model where they're collecting all those numbers together. They're looking at your LSIR number as well as child safety, parental capacity, and other. There's different standards used in other states as well. Most of them are using GAIN, CAGE, or UNCOPE. And CAGE is the basic, do you need to cut down on your drinking? Do you feel annoyed by other people complaining about your drinking or drug use? Do you feel guilty about it? Do you need an eye-opener to get started for the day? UNCOPE is pretty similar. Do you find more time using than you intended to? Have you neglected traditional responsibilities? Do you need to cut down? Does anyone object to it? So those are all screenings that get to the issues, but criminogenic gives a nice firm number. And there's the stat for dual diagnosis. This was an attorney's personal interpretation of her clients, but she felt like 80% of them were dual diagnosis. So definitely seeing a lot of clients who have high needs.
Are you all passing out handouts on this?
We'll distribute them electronically. I apologize that we're not able to in paper.
But we'll make sure we get a lot of
Yes. And so another ethical issue that we really wanted to talk about a lot, and is one of the central issues for us as attorneys, is confidentiality. And so a lot of us have a conception of confidentiality when we have clients, that our client communications are really sacred, and that there are very limited instances in which we're communicating what our clients are telling us with anybody else. Working in family treatment courts is a little bit more nuanced, right? And we've mentioned before that the whole idea of this process is that it's non-adversarial, and really the goal is to work on treatment. So there's a lot of information that folks are going to learn about your client. And so really one of the things that we run into is folks, parent attorneys especially, not wanting to refer their clients to get this service and go into this court because of all the information that's going to come out about them. And there's a fear that it may be used against them in their underlying dependency cases. And so having an idea of how you can still encourage your client to participate in these courts at the same time maintaining your ethical duty of confidentiality, we thought was really important to discuss a little bit. So the structure of some of these courts is one of the reasons why this is such a challenge. So in an integrated court, as we mentioned before, you're going to have the same judge that's hearing your underlying dependency case that's also hearing what's going on in your drug family treatment court. And so one of the parent attorneys that we talked to said that judge is going to have 10 times, 20 times more information about a participant than a non-drug court participant. Right, so there's different ways to manage how that interaction works, how the interaction looks, but it's something that you need to be mindful of, that not only the judge but other folks, whether it be the SAG as a part of the team or the GAL or other, all the different parties are going to have a lot of information about your client. And really, one of the best ways that we thought for you attorneys to manage what happens at staffing is really to participate. So one of the things that we heard in our conversations with folks is that the staffings aren't mandatory in a lot of different places throughout the country. And so really it's on the parent attorney or the child attorney or the GAL or the SAG. It's really up to them whether they participate. And we're trying to stress here that for these confidentiality reasons, it's very important to know what's being said in those staffings behind closed doors before you get out into open court. It's important that you show up not just in court in front of the judge and talk about what's going on in the case, but also that you're participating in the staffings. And then it's just a fact of the matter that some of the things that are discussed in your FTC, staffings, especially in integrated court, that information is going to come up again. That information is you're going to see it again in the underlying dependency hearing. And so really you want to just make sure that you're remembering in the back of your mind, if you're having conversations with your client about the things that are going on in their life, you want to try to balance, their treatment goals with your ethical duty, and really remember that although this is a non-adversarial system, we're working together as a team and we're trying to get this person really good treatment. Your duty is just the same as it is in any other kind of practice, that you're not authorized to reveal information about your client that your client does not expressly authorize you to reveal. Oh, that was the wrong button. There we go. So there are a couple different best practices that we came across in different jurisdictions across the country. Really, one of the best things that we saw was having an MOU, a memorandum of understanding amongst all the team members. It talks about what kinds of information is okay to disclose outside of that staff meeting. What kinds of information can be used against your client in an underlying case. So in the Alabama standards, it says services and confidentiality will be addressed in the MOU. And I think that that's really a best practice. You want to have these things, ironed out on the front end so that you're not at risk of having more information come out about your client than you would like to come out. And you're also talking to your client about how the information is going to be used. You don't want a situation where your client is afraid to tell you, whether they relapse or whether something happens to them that's going to affect their treatment. Again, at the same time, better treatment is going to be better for their case in the long run. It's going to create a better outcome. So you want that open line of communication. But really, one of the good ways to do that is ensuring that the participants in the program, they know how their data is going to be used. They might not be fearful that everyone's going to know that they're using a certain drug. So consented disclosure, for example. You may want to let your client agree to consent to have their information used for research, but not for other things. And then one other recommendation that we came across was to keep confidential information out of publicly accessible files. So all those different things that are going to come up in the course of a staffing, your drug screenings, how you're doing your progress report, other things about your family and your home life, you kind of want to keep those things out of records that are going to be publicly accessible. And again, we stress this a lot. Participation is key as a best practice. It's hard to know what information is being exchanged if you're not in the room.
How do you keep the other participants from talking about the participants?
So typically, the staffing is typically only the attorneys that are on the case and the treatment providers and the judge. And so there are no other participants that are in that particular area. So by the time you get to the general court session where there may be other participants listening, you want to already have ironed out what information is going to come out about the person. And really, the information that you want to come out is about their treatment, right? So you want to know whether the person relapsed. That's not the kind of information that we're talking about. We're talking about information that's going to be harmful to their ongoing dependency case. So I hope does that answer your question? Okay. Another thing that we're going to talk about that we thought was central is diligence, and especially for folks that work in the child welfare context, being diligent and acting with, promptly and responding is really important, especially when you're backed up against the ASFA timelines. And so there are a lot of different, the ABA commentary is the SPPA is the parent attorney commentary. So delaying a case, you can increase the time family is separated, reduce the likelihood of reunification. There are all kinds of things that can happen if your case is delayed and delayed and delayed. And at the same time, you really have to think about, is this good for the parent? Is this good for the child? If your child is sitting there in foster care, you're not going to want to take unnecessary continuances. At the same time, if you're working for the parent, treatment takes a little while. From some of these courts take 18 to 24 months, so it might take a little longer. So you really want to try to make sure that you're not unnecessarily delaying the treatment that's already going to take a long time, or a significant amount of time, I should say. Again, we talked, Julie talked, I think, talked a little bit of the ASFA timeline, so, and I'm sure you all are familiar with it. This is an issue that a lot of the folks, the parent attorneys that we talked about, we asked them, was there a concern that, the SAG are going to move for a TPR if your client goes to treatment court? And what we heard almost universally is that, when considering TPR, considering the ASFA timeline, if the attorney's on top of it, that the parent's participation in a treatment court is going to be a pretty good reason for the SAG or whomever to get a continuance or to move outside of that ASFA timeline requirement. And so really, you have to be concerned about it and be able to articulate the reasons why your family treatment court is good for that child and for that situation. But it's not something where participating in a treatment court is automatically going to bar, automatically going to put you outside of that ASFA timeline. And so really you have to think about whether the issue is reunification or permanency. So Julie talked about this a little bit as well. If your timeline is focused on reunification, there's some data to indicate that a lot of times this can happen a little bit faster. The child goes back into the home when the parent is in this intensive treatment. Permanency will take a little bit longer as you're working in the court. So these are all things that we want you to think about in terms of diligence. And even here, it's come to a head this past session. So in addition to some of those other screening mechanisms to get into family treatment court this past year, Georgia legislature passed a law that kind of incorporated some of the family treatment court, the longer process for family treatment court into the law. So it increased the time before custody can be transferred back to the guardian in a dependency case caused by substance abuse. Originally that was 6 months. Now it's to 12 months if you're not in a family treatment court, or it can be earlier than 12 months if you are in a family treatment court program. Yes, ma'am.
Ticking if the child is in the custody of the department but remains in the home with the parent.
I think, and Mother Melissa May can help me with this, but my understanding is that when the child is reunified, that ASFA timeline is not
It's a foster care clock.
Yeah. And so diligence is important. And when we were talking to folks throughout the country, we heard a large amount of variability in the responses. Some folks said 6 to 12 months. Some folks said, the cases go longer, but the kids come home faster. So some folks said, as Julie mentioned, one of the cases that we heard about went for 4 years. And so really, you have to be very intentional when it comes to your case and working with your parent. And really working with the family treatment court to make sure that they have an idea of, what timeline are we trying to achieve? What's the optimal amount of time we think that this participant should be in the court? In terms of best practices, again, asking the question, what is the court focus on? Is it permanency? Is it reunification? In Jefferson County, the video that we showed, they had data to back up that question. So when the attorney asked, and the attorney's deciding whether it's best for their client to go into family treatment court versus some other kind of intervention or just do the regular dependency process, they could come back and say that the FTC children came back 28 attained permanency 28 months earlier than children in the regular dependency case. And 11% more children were reunited with their parents or their family members. Iowa had a similar positive gains, and 80% remained in custody of parent compared to 43%, and the median time to reunification was 41 days. So this, and you can see in this data, here in Georgia, the time is 6 months, and so, yes, question.
What you had in your slides, reunification versus permanency, but in my experience, reunification is the #1 goal for permanency.
Right, and let me clarify. Reunification with the parent versus permanency in another placement. Thank you for asking that question and clarifying for me. And so one of the things that is really another best practice in terms of diligence is to be able to make the argument that the FCC is going to have better outcomes, arguing that the court keep track of the data. Obviously, we're attorneys. A lot of us are attorneys. asking for data is not necessarily something that's in our normal course of business and representing our clients. But this is something that, it's really incumbent upon the attorneys in practice and all the team members to make sure that the court functions the best way that it can. One of the best ways to do that is to have data about how long it takes, kids to come back to be reunified, what are the other permanency options that are achieved, how long are people staying in the program. That kind of data is important to know when you're really trying to make an informed decision about whether to participate in these courts. Sure.
Any of these jurisdictions, are they utilizing parent advocates, and have they seen any significant benefit in the use of parent advocates, or any jurisdiction that you all have looked at?
I'm not so. I think typically the person that represents the parent in these is an attorney. We didn't hear as much about parent advocates. A lot of times it would be the decision makers would be someone from the department, the judge, and the treatment providers. So I think that most of the time that role is fulfilled by the parent attorney. I'm not sure that Juliana.
I can jump in. So in our interviews, we didn't talk to anyone who specifically had a parent advocate who said, we have a parent advocate as a member of our team. I did have a few people who referenced that when someone graduates, that they might be able to lead be a peer mentor or be involved. So it sounds like there is an informal support group in some of these. I think I heard that from maybe 2 or 3 people that they do have peer mentors, and it's also a really nice way for someone who graduates from the program to still have that network, have that support. Like Andy was saying, it's one more reason to not go back down that road because you're still in touch with the system on a regular basis. I know that the parent advocate community is really strong, specifically in New York City. And we talked to some courts in New York, but not in New York City, so we didn't have that overlap.
Yeah. Other questions? Okay. And so I will turn it back over to Julie to round out our ethics discussion.
So the last ethical issue, and again, these were just the 4 that we were hearing the most about from our interviews. There's obviously a lot of ethical issues for attorneys out there, is zealous advocacy. And we were surprised when we started our research to see that zealous advocacy itself isn't even in the ABA model rules anymore. It's kind of shoved back into just a comment on diligence, but it's something I think we all know and we all learned in school and know from practice the importance of it. And even though we keep referring to family treatment court as a non-adversarial court, that it's still very important to bring zealous advocacy. So there's a couple different ways that an attorney can make sure they're doing this. It's going to be a little bit different in every court, but attendance being there is a huge thing. And the few courts that we talked to that said we don't require attorneys to be there or the attorneys never come to staffings, we were really surprised to hear that. So it's obviously a big concern. Pushing back from admissions and sanctions, just because your client has agreed to participate in a court does not mean that they've agreed to accept every sanction that the team or the judge decides to suggest, and then dealing with conflicts that I hinted at earlier. So dedicated parent attorney varies a lot. Heard from a couple people, especially program coordinators, that it could feel awkward at first to have them in the room because it feels like you have a judge, you have treatment providers, you have everybody talking about it, and then you have the parent attorney who, again, maybe doesn't want to reveal any of the client's personal information, but you need them in the room because that's where possible treatment, possible sanctions are all being discussed during that staffing. So it's really important for them to be there. In New York, the standards were really great. Terrence led our research for New York. And this is one of the states that had 300 pages of standards, and they wrote out exactly what the attorney needed to do to still be a zealous advocate, that the ethical and legal requirements of family court practice do not change just because you're in a treatment court. And even though you're part of a team, you still have an obligation to represent your client. So we thought that was great. Every state really needs to have that set out separately because we found that lacking in the other state standards. The idea that you're not there just to rubber stamp the approval of the rest of the team, that you're there to represent your client. One of the issues that comes up is clients that are going to test positive during a urinalysis. They could be required as frequently as 10 times per month. in the first phase of treatment. After that, it might drop back to once or twice a week, but there's a lot of tests. Substance use disorder has about a 60% relapse rate. It's up there with other chronic diseases like diabetes and asthma. So relapse is to be expected. It's part of the medical diagnosis and treatment and understanding of substance use disorder.
With regards to the attendance at the staffings, was there any research done on whether or not the issue of payment to the attorneys came into play? And I ask that because I know in Fulton County, we have a parent attorney office. And so we have a parent attorney who is assigned to the family treatment court. But in some of the other jurisdictions where the parents' attorneys are appointed to represent the parents, sometimes the court may or may not pay for, attorney representation outside of the main case. And I've heard that just in terms of regular dependency proceeding, where some parents say, well, they don't go to the panel reviews, or they don't go to this because the court doesn't reimburse them for that. So has that ever been, has that question ever been asked, or, is that a consideration with regards to because my opinion is that attorneys will go anywhere that they get paid to go to. So, is that a factor in, the attendance issue?
That's a great point. I remember it coming up in one interview, and Terrence, you might be able to fill in more, but that an attorney said, I show up for court, I don't get paid for the other thing. So it did seem like that could be an issue. I only remember it coming up once.
Yeah, and I would also say, I think a lot of the attorneys didn't feel like their presence was necessary at that treatment court, at that staffing. So, maybe it's not they're getting paid. That is definitely probably something that has an influence. A lot of attorneys that we talk to as well, they express that, this is about treatment. This doesn't have really anything to do with me. I don't necessarily need to be there is another reason that we heard.
They're getting paid, they're going to be there whether they're needed or not. You know that.
Probably so. I don't have a definitive answer on that, but probably so. There's another question in there.
It seems that if they sign a waiver, that anything that's said in the treatment court can be used against them in dependency court, then it would be incumbent on the attorney to know what's said in the treatment court to defend their client. That's just good practice. And I follow up on your, all across the state in the various circuits, attorneys are either hired by the hour, you have to turn in a voucher at the end of the month to get paid, or they do a contract. And so, like you said, it depends on the circuit as to whether or not the judge is going to reimburse them for attending the treatment court, just like family team meetings or anything else. They may not get reimbursed. And they may, when they take on a contract to represent and be the parents' attorneys or guardian ad litems, if that's not taken into consideration as the number of hours they would be spent on their contract, then that seems to be a chilling factor for taking on a contract, because as you all may not know, but this representation in family courts is probably the lowest reimbursed hourly rate for any attorney throughout the whole state. Shut my mouth there.
So to answer the first part of that in terms of what can be used, we found in a couple places where there was a concrete description of what could be used, that the information that the parent had been part of a treatment court, and the information if a parent didn't graduate and was terminated from the program, that would be transferred back to the original court. In theory, the things discussed in the treatment court shouldn't come back to the original dependency case. That brings up one of the issues that we thought was really interesting when we were talking about people with parallel or integrated courts. It was about a 50-50 split, and the Children and Family Futures Standards, which has pretty strong guidance on most issues, said you can do either. But we thought there was a pretty big issue when you have the same judge serving for the dependency case as well as the family treatment court, because it's really impossible to ask any individual human to compartmentalize that they know someone who's in front of them every week for court. For FTCs, the goal is that the judge talks with the person at least 3 minutes. So you're seeing them every week for 3 minutes, maybe 5 minutes. If they fail 6 months later, you're not going to suddenly forget that they've had a certain number of failed tests. So that would be an argument towards having the parallel court where the judge would find out parent entered treatment, parent did not complete the treatment program, parent's case is transferred back to the traditional dependency court, and ideally the details would not travel with. I can't tell you that it actually always achieves that result, but that's the hope behind it. To know. As for the reimbursement rate and the hourly issue, when we were talking to different states, we were hearing that they either used a panel of attorneys that would be paid hourly to come in and represent, or in a few cases, they would have one attorney that was tasked to be on call and basically take all the cases that came in. The positive of that is that attorney, their full-time job was the treatment court. They wanted to be there. They wanted to be part of it. They knew the mission. And we felt, and I think I'm going to get to that in a few slides, but they felt that that was a productive part of their experience. They wanted to be in the court, and that those attorneys seemed more successful in this sort of thing. So obviously, if the attorney is paid to be in treatment court, it's going to be a better result for everybody. I don't think anyone in the room would question attorneys getting paid for that work.
I can see a big issue with judges hearing everything in confidentiality and also unringing bells. Is there any consideration given to somebody that's like a hearing officer that's detached from the court but acting as an officer to hear those cases?
I don't think I've heard anything on that. I don't know if Andy Melissa has any thoughts, so I think that is a completely new novel topic for us today, so maybe something for some further research. So we talked about attendance. Alabama, Idaho, and Oregon were the states that said there's got to be a dedicated attorney, and again, so that's a best practice. The idea of having just a generic attorney who maybe sometimes they take dependency cases, maybe sometimes they take criminal cases, just jumping in and not having the training, it was a really big concern for us, and the New York standards, again, were the best standards we found in really saying what you need out of an attorney. Alabama, Georgia, and Oregon all require the attorney to be there for the staffings, so it was great to hear that from those jurisdictions. Other ones said 50-50 whether the attorney's there, and in New York it was great to hear. I've never met a single, not great, it's obviously sarcastic, but never met a single attorney in a single case, even in terminations. And if I was up for termination, I would have an attorney present. So it's crazy to think that people would meet in a staffing. The decisions are usually, the options are discussed, and people do start to make up their mind while they're in staffing. And you come back into court, everyone already knows what the result might be. And that's where the attorney is stepping in, especially if it was someone facing termination. It's scary to think that there wouldn't be an attorney present for staffing.
We're talking about termination from the program, not termination of parental rights. Just people have asked that question.
Thank you.
We're going to revise that quote.
We're talking about termination from the program. I know y'all were scared for a second. Set your mind.
So for admissions and sanctions, one of the thoughts I think that earlier comment led to was you're signing a piece of paper to agree to this program. And it's important to remember that just because you're signing to agree, you're not agreeing to the sanctions. The attorney absolutely can and should be pushing back in the hearing. The failures of your analysis are pretty high, whether it's because it's actually a positive test or because the client didn't have transportation or childcare or $10 copay or whatever other thing they needed to be able to get to that test. The sanctions we heard from were pretty varied. In most places, they recognize that reducing visitation and jail time don't make sense. If the goal is reunification, visits are the best thing you can do working towards reunification, and reducing visits and jail time make absolutely no sense. But we talked to one program coordinator who said, first offense, 2 days in jail. Our judge wants a wake-up call. Second offense is 7 days in jail. That was a far outlier. The rest of our courts were not like that. There was one other court that said they do use jail, and that was here in Georgia, that they said, you know, you do get a day or two or up to a week for the third time for sanctions. So they can be there. Attorneys absolutely should be zealous advocates and push back on those things. So in terms of admission, so getting into the family treatment court in the first place, they're going to be making an admission that sometimes it's that they used it and it led to abuse or neglect, or used it and that it's impacted their ability to parent. One program coordinator we talked to had a really great approach to this, and the coordinator just said, we asked them to consent to receive services. It was so much easier just to change the wording a little bit. And I recognize the humanity of the person in front of you and say, do you consent that your substance use disorder has impacted your ability to parent? Rather than sign this, you're guilty, you're a bad parent. So that little switch in wording was huge, and made an example that admission might not be the worst thing, but that you can try to get it worded carefully for your client. So sanctions talked about pushing back. Any failure is potentially going to end up on a record, could stay in the judge's mind, could follow you back to the traditional court, even if they're not supposed to. And only New York really had it set up for how parents were going to challenge the alcohol or other drug standards. So talking about where the lab work is being done, how it's going to be pushed back against. New York was really our only state that had that. And also the importance of not relying on jail as a sanction. There's a lot of other sanctions, whether it's community service or writing a letter reflecting on your experience, but jail and reducing visits just don't make sense. So last big issue we found, and this was probably the thing that surprised Terrence. Do you want to talk, Andy? Go for it.
Yeah, I was just going to make a quick comment about Georgia, that in the standards for Georgia, the participants should be able to contest. So if they have a positive screen, they have the right to contest without the burden being upon them to pay for it at that point in time. And so that means that you would take a local screen or whatever the technology is, they get to send it out to a reference lab. If it comes back positive, you know, then action is taken at that point. But the principle is that they should be treated at the point where they contest as though they're innocent, you know, until the analysis comes back or the screen comes back. The other thing is that with the use of jail, that there is some variability, that the family treatment courts are encouraged to incentivize honesty. And so if a participant does acknowledge use prior to a screen, that they won't use jail the first time. And that they, you know, though there is some variability on this, but to go easy on the use of jail. For one, it's a civil context, but also it can be counterproductive. But jail is used as a higher order sanction in Georgia as well.
I have a question in the back.
Sir.
Payment for the drug screens, I saw something about $10 or something like that. If they admit honest, is the payment waived? Or if they test negative, is the payment waived?
In the event that a test comes back negative, so they contested it and it was sent out.
No, I mean, do they pay $10 for all tests or only if they're positive?
In Georgia, they don't pay for the test. It's covered by the court unless they elect to send it off. If it's contested and it came back positive, they would be responsible to pay the fee for that, which is, you know, I think reasonable. But otherwise, it's that cost is incurred by the program as it should be.
Sorry if I'm mixing things. We do have information from 7 other states, so sometimes I throw out some things. There are nominal fees in some locations. Sometimes they're waived. I think the majority of people going to these programs usually are indigent, so it makes sense to have them waived. So we'll just do a few minutes more and then get to some questions. So conflicts, the craziest thing that I think Terrence and I saw was the idea that I discussed earlier of one attorney serving for both, for the parent and the child. And I see some shaking heads. Obviously, it's not a system that would work, and it leaves the child in that case without representation. So a parent attorney should always be alert to and avoid any potential conflicts of interest. And I know under Georgia law, if you're appointed to represent both, and you're not in a position, if you're representing the child, you're no longer able to provide that representation, that you're supposed to identify that to the court if you're the GAL and have someone else come in as the parent, as the child attorney. So ways of dealing with this, we talked about 3 states earlier that have that designated attorney who represents the parent in the court. So that's one of the easiest ways. Most courts that had that have 2 attorneys on staff, so that allows coverage for vacation or for conflicts. We also talked to one place that had a judge that could serve as backup. Other places did not have backups if there were conflicts with the judges. So that was definitely an issue we were spotting as FTCs grow. It's good, there'll be more judges and more attorneys that are capable of handling this, but there's also going to be more conflicts that pop up. We did have one judge who was able to recuse themselves, and they said it was, it was unusual, but they were able to do it and get coverage from another jurisdiction. So one big takeaway for today, for anyone who's not in FTC, because that's the majority of the room, is that some of the best things that Andy really talked about a lot that you could take back to a traditional court right away is one of the guidelines for an FTC is the judge spending at least 3 minutes with each client, getting to know them, showing that their opinions, their efforts to get reunified, to work on whatever services the parent needs to work on, that makes a huge difference. And you can always argue for that your client needs more time getting assistance. And for example, New York is doing that. They have a number of FTCs, and they've recognized that they're not going to be able to develop an FTC in every jurisdiction, but they are asking other jurisdictions to start picking up these best practices. So that is about it. So we are open for a few more questions if you guys have any, and we have our contact information. Terrence and I did a lot of research statewide, but also in terms of national. Children and Family Futures and National Association of Drug Court Professionals are amazing resources.
I just have a quick question. In the jurisdictions that you studied that have the family treatment courts, of course you mentioned the parent attorneys, but in those jurisdictions, do they also have attorneys representing the children? I know you talked about the instances where there might be a conflict, but for the most part, are you finding that the children's interests are represented separately from the parents?
So in the family treatment court, the focus is on the parent, but if it's a parallel case, in the traditional dependency case, you're still going to have a child attorney involved as well. I think most of the courts we talked to still had a child attorney, but I'm trying to think whether it was required. And that's someone who would be
I
part of this.
understand that in terms of the dependency court, but in the family treatment court, because the outcome of the family treatment court also impacts the child. So what I'm asking is, within those courts, are you finding that the child is represented in those courts? They are represented in Fulton County. There's a child attorney who is there on behalf of the children in those cases. But so you're just finding basically that there's a parent attorney in those courts and the SAGs and
I know
the
New
service
York.
providers.
New York had child attorney guidelines.
Yeah, I think it varied, but I think that.
So, and I think guardian ad litems were part.
Yeah, I think that there was a representative. I mean, I think that when we're talking about the parties, some places explicitly recognize that the child interest should be represented, whether it be a child's attorney or a GAL type person. But there were some courts, I mean, again, there's a wide range. I think that on the best practice side of things, we would definitely think that, representation for the child's best interest and for the child is important to be in that staffing. Because there are going to be times when, things that are good for the parent and their treatment is not going to be good for the child in that same context. And you really want your staffing to be able to work through all of those different conflicts, those different challenges together. So I think it's important to have the children's attorney there at GAL.
And it's important for the children to have an understanding of what's going on as well in terms of their parents' progress and whatnot.
Right. We would agree with you.
I don't want to cut off questions, but I do want to be respectful of everyone's time, and we've reached the conclusion of our program. So I want to make sure while all of you are here that you join me in thanking our visiting scholars and pastors. I know I and all of them thank you for for your interest and for your thoughtful questions that you brought forward. It's really helped, I think, sharpen everyone's thinking about how these courts operate, for what purpose, and in what way in this state and elsewhere. So thank you for that. If I failed to mention it earlier, or even if I didn't, I'll just repeat. There is a program evaluation that we would very much appreciate you sharing your thoughts about today's program and going forward if you have suggestions for other programs. In exchange for doing so, you may have a parking voucher for the hospital visitor parking lot, where I assume most of you are. That parking voucher is good, just FYI, for 3 hours on campus. So if you have some time and you want to explore, there's that for about another hour. And otherwise, if you were otherwise here for a longer period of time, just know that the voucher is for 3 hours and the rest you would be expecting to pay at the exit. So I think that's it. So again, just with my thanks for all of you for today's program, I wish you all a good weekend and enjoyable summer.
Thank you.
Thank you. Thank you.
Andy?